and welcome to Rajput, Jain and Associates. Today in this video we'll discuss about alteration of Article of Association. So starting with the meaning of Article of Association. Article of Association is a document which contains the rules, regulations and bylaws which are useful for the internal management of a company. It defines the powers of its officers and also establishes a contract between the company and the members and between the members as well. Now we come to the alteration of Article of Association. So, as per Section 14 of the Companies Act 2013 and subject to the provisions of Companies Act and the Memorandum of Association, a company may alter its Article of Association by passing a special resolution. It is utmost important to note that being a fundamental right, no company can deprive itself or its members from exercising such alteration. Now, where the company wishes to alter its AOA, they would be required to file an application in Form INC 27 along with applicable fees and same be submitted with the ROC. A company may alter its article by adoption of new set of rules, addition of new clause, deletion of a clause, amendment of a specific clause, substitution of a specific clause. Now, having discussed about the meaning of all Article of Association, we now come to the conditions which a company must adhere to for altering its Article of Association. First of all, the alteration must not exceed the authority of the memorandum or shall not be conflict with the provisions of the memorandum. Secondly, alteration must not be inconsistent with the provision of the Companies Act. Apart from this, the articles must not be altered to add anything which is illegal or opposed to the public policy or unlawful. The alteration should not be against the tribunal's order. Alteration should be bona fide for the benefit of company as a whole. Alteration should be bona fide for the benefit of company as a whole. Also, the alteration may be made with retrospective effect if it is bona fide for the benefit of a company as a whole. Then the alteration should not constitute a fraud on the minority. This means an alteration to the articles must not discriminate between the majority shareholders and the minority shareholder, so as to give former the advantage over the latter. Any alteration which compels an existing member to take or subscribe for more shares or in any way increase his liability to contribute to the share capital without his written consent to the same shall be invalid. An alteration which enables the board of directors of a company to expel a member is illegal and void. And lastly, the alteration should not be enable a company to commit a breach of contract with the third parties or avoid a contractual liability. Thus, an alteration of article shall not be valid if it enables the company to commit a breach of independent contract, and the company shall be liable to contracting party for damages. Now, coming to the last part of our video, we'll discuss about steps involved in alteration of Article of Association. The first step is to convene a meeting of Board of Directors. For this, a notice of board meeting be issued to all the directors of the company at least 7 days before the date of the board meeting, and same be delivered to their address. Along with the notice, an agenda, notes to agenda and draft resolution will also be attached, which will provide brief information about the business to be transacted in the meeting. After this, meeting of Board of Directors to be held on the decided date, time and the present quorum shall pass the necessary board resolution in respect of alteration of Article of Association, authorization of company secretary or any director to sign and file the relevant form with the registrar of companies. And lastly, to fix the date, time and venue of the general meeting and to approve the draft notice convening the general meeting along with explanatory statement annexed to the notice, and authorize the director or company secretary to sign and issue notice of general meeting. Lastly, the company secretary or the authorized person is required to prepare and circulate draft minutes within 50 days from the conclusion of the board meeting, and same be served to all the directors of the company. Next step is to convene general meeting. A notice of general meeting shall be served at least 21 clear days to all the directors, member, auditors of the company, secretarial auditor and debenture trustees, and to others who are entitled to receive the notice of the general meeting. Notice shall specify the day, date, time and full address of venue of the meeting and contain a statement on the business to be transacted at the meeting. Then, the general meeting to be held on the day and date specified in the notice. The present shareholders shall pass a special resolution for alteration of article of association. After that, the authorized person is required to prepare the minutes of general meeting and get them signed and compile them accordingly. Next comes filing of Form MGT 14 with ROC. Form MGT 14 is required to be filed with the ROC within 30 days of passing of special resolution in the general meeting. This form is required to be filled along with documents like certified true copies of special resolution along with explanatory statement, copy of the notice of meeting being sent to members along with all the relevant annexures, altered article of association, copy of attendance sheet of the general meeting, and also the shortened notice consent where the meeting was called by serving a notice. Lastly, alteration of articles is required to be noted in every copy of the articles. So, whether stamp duty is required to be paid on alteration of article of association? The answer is no. The Act does not contemplate new articles of association, and where it proposes to be, it is nothing more than a special resolution, and as such does not require to be stamped. Next, whether mistake in article of association can be rectified by the court? The answer is no. A mistake, whether clerical or any other in the article of association of a company, can only be rectified by altering the articles by special resolution in accordance with the section. It cannot be set right by the application to the court. So, this was all about the alteration of article of association. For more queries regarding the same, contact Rajput, Jain and Associates. Thank you.